Hello, everyone. Welcome to the IEP Toolkit. Sorry that I was unavailable yesterday. I was actually in a trial all day. And unfortunately, I will not be with you the rest of this week because I am going to take my son to college. So I welcome you today. We're going to talk about some really important topics. And I want to really focus on those. But before, I'm Lisa Kirsch Satawa. I'm an attorney with Kirsch Daskas Law Group, where we take a different approach to different learners. And today I want to go through with you this publication by the Michigan Department of Education. And I will put the link on our Facebook page as soon as we're done. But basically, this is guidance given out by the Michigan Department of Education for what they're calling foregone learning. Foregone learning is kind of a new term, but it basically is learning that was, or instruction that was not available because of school closure and the pandemic. Now, we've talked about before that the IDEA was not relaxed in any way, shape, or form by the CARES Act. So as far as the delivery of instruction and accommodations for that instruction, access to instruction, all of those responsibilities were still on the school district to make that learning available to special ed students if it was going to be given to gen ed students. So, and it was, or they tried. As we all know, it was kind of a last minute emergency, oh my God, like schools are closing, what are we going to do kind of panic situation. So they tried to do the best they can. I would assert to you, no one did it right. No one did it well enough. It was just, there was no way they could have. It was an impossible journey. And especially children with IEPs who needed individualized education, and to put that burden, individualized education, virtually or distance learning in like 24 hours. Wow. So now the Michigan Department of Education has recognized that regardless of the Herculean efforts, actually they call them the significant efforts, Herculean was my word, that districts made, and following their continuity of learning plans, there's been all kinds of approaches, and that there are a lot of issues. So the Michigan Department of Education came out with this report in July, which recognizes some specially designed instruction related services and supplementary aids and supports may not have been provided and may have resulted in a regression of skills or affected the student's ability to make progress in the general curriculum. So, students with IEPs may benefit from recovery services due to COVID-19 pandemic. So what that means is that there are additional services that are not a mandatory requirement, but that should be requested and provided to help our learners get to where they were or beyond that when schools were closed for the pandemic. Recovery services are different than compensatory education. Recovery services, as I said, are not mandatory. Compensatory education is mandatory. Recovery services are not mentioned anywhere in the IDEA, where obviously compensatory education is. There's also no mention of recovery services in the MARS rules, which are the Michigan Administrative Rules for Special Education. And certainly recovery services are supplemental in the offer of FAPE, but they are in response to foregone learning. They're not something that was contemplated or awarded before. It is a measure to mitigate the potential additional impact of loss that a student with an IEP may have experienced. Now, Recovery services, remember, are supplemental. They're not required. They're not mandatory. They're not in the law. Compensatory education is to make the child whole again. It's to compensate them for lack of learning when there has been a violation of the IDEA. So when they've been denied due process, when they've been denied a FAPE, when they've been denied access to education. So it's different. So the services provided may be exactly the same, but the label is going to make them different. So recovery services are put in place to support and potentially add an additional factor to help students make progress on their annual goals. It's allow the student to make progress without further delay. So whatever those recovery services are, they should be in place before school starts, and the child should be used to using them, whether it's technology based or it's, you know, a Zoom base, or it's a pod, or it's they can come in any different services. But remember, these are not mandatory supports, but they are now being offered and should be taken advantage of by parents for their students in order to make up for the loss in progress during the shutdown. And as we know, our new IEPs have a huge problem because we don't have any baseline data for where our children are now. So maybe with these recovery services, we can then start to measure the progress. We can formulate new goals. We can formulate a new IEP. We can go forward from there and then decide if compensatory education is still needed and if it needs to be sought. Recovery services, again, do not replace or jeopardize a child's right to compensatory education, and that compensatory education is part of due process that's guaranteed under the IDEA. And it is the remedy when it's determined that a school district has denied FAPE to an individual student. It's typically awarded as a result of an educational loss that is identified in the complaint. And then the final decision is by the administrative law judge in a due process hearing or due to identified noncompliance as a result of the state monitoring activities. So the decision to put recovery services in place is made by the individual districts. And I would encourage you that I think that districts would be willing to put in recovery services for all students who have IEPs, only because they're going to get hit at the back end with compensatory education issues if they don't try to get that child back on track now. So that's really important. The MDE, Michigan Department of Education, has also said that recovery services must supplement and not supplant, I love that, the student's existing educational program. So the services should be individualized. They should be given in response to every goal in the IEP to try to cause the progress line to turn and start an upward trend in progress instead of standing still or going backward, which is what the MDE has recognized has happened to Michigan students during the shutdown. MDE is encouraging but not requiring that member districts and ISDs consider making recovery services available. They're not automatically warranted because a student failed a class. They are warranted if the student doesn't have the skills to succeed in the class. It's very, very important. It should be the underlying theory of recovery skills is regression. If you have a situation where a child has regressed, and you want to put recovery services in place so that they can recover their lost ground and be at least where they were before the shutdown. It's to regain skills, and that's where when you're looking at the IEP and you're looking at and listening to parents who are so prepared, advocating for where their children are now and things they could do and couldn't do during the shutdown, what they had access to, what they didn't have access to. This is where it's all going to come in for recovery services to be figured out. So foregone learning is a new term of art that we're seeing, and it basically just means the learning which could have occurred in the absence of COVID-19. Recovery services are specific to additional foregone learning and that students with IEPs have experienced. The MDE is also recognizing that circumstances can change due to unpredictability of COVID-19 and that they have to be ready in case there's another surge and it becomes mandatory for everyone to be at home again. We talked about the other day that a lot of school districts don't want distance learning in the IEP. They don't want it in the IEP because then you have a remedy of filing due process if you don't get the services or the supports or the accommodations or the access to education. That's more of a burden on them and there's more accountability. However, as a parent, as an advocate for your child, you should absolutely be talking at the IEP meeting about distance learning, about recovery services for students. Recovery services, as I mentioned, must align with the IEP. So each goal can have some recovery services to help the student get back to where they were before. It may not necessarily replicate services provided as part of the current offer of FAPE, the IEP, but it should be pretty specific and talk about frequency, duration, type of service. They should each support an annual goal, and it's an effort for student progress in the general curriculum to be monitored and for that student to have access. And these additional recovery services can take place within a normal school day. When looking at what factors should districts consider when determining whether recovery services are warranted for students with IEPs, the biggie is, has this child regressed? And then the document gives you a whole list of the analysis, and then it goes through reevaluation, and it really talks a lot about observations from parents and other family members about the student's ability to access learning from distance options and special education services during the interruption of instruction. It talks about progress, it talks about level of academic achievement, and their access or need for extended year services. And the IEP team should be looking at everything from a scheduling standpoint and how we're going to put it in place and how are we going to accomplish it. So, much of the data that is known is from, those last couple months of remote instruction. So there's going to be a lot of moving parts in creating a recovery services plan. The determination for recovery services is different than an extended school year analysis because regression and ability to recoup are important factors for determining both of them. However, ESY, extended school year, is a predictive analysis. We believe this child's going to fall behind, so we're going to have them go through the summer to catch up and to gain that additional benefit, where recovery services, the team is looking at the actual impact of the interruption on the child's ability to learn, or ability to access education, ability to make progress in their IEP goals. So they are very different. Schools they must consider the individual IEP, the individual student, and what the extent recovery services will actually be successful with that individual student. They should consider information collected and data from prior IEPs, from prior lapses in learning, and absolutely listen to the parents. Some of the mechanisms that can be put in place as recovery services could include, selecting tools that can be used more frequently and are more sensitive to small changes over shorter periods of time. So those are kind of your buzzwords. When you're working with the team as to what the recovery services should be, you want to tell them that you want tools that can be used more frequently and are more sensitive to small changes over shorter periods of time. That means that we're going to see when a child improves from reading 10 words to 11 words, or 10 words to 15 words. We're not going to have to wait for them to read full paragraphs and full books. That's a very simplified explanation, but I think it makes the point. Like everything else, you want to bring this to the IEP team's attention before you get to the meeting, that you believe your child has regressed and you need the meeting to consider recovery services. You want this to be in writing. If you don't notify them in writing and ask for it in writing, it never happened. You never asked for it, and it may not happen at the meeting. If there's a delay in determining eligibility for special ed because of COVID-19, the district absolutely, positively should consider whether recovery services are warranted, even if it's just because of the delay in determining the eligibility. The recovery services are funded by the CARES Act, Elementary and Secondary School Emergency Relief Fund, SSER. So our district doesn't have money for that. It's not a valid excuse. The procedure that should be followed when determining whether recovery services are warranted is basically, it's a discussion. It's not really formal. It should be with the entire IEP team. And if the question is whether or not this child has regressed and to what extent recovery services may be warranted for a student with an IEP. It may be a revision amendment to the IEP that adds the recovery services, but that is really, really, it's really important that it's in writing, and it's really important that there's parent input, and parents must agree to recovery services being put in place. The school just can't say, yep, you regressed, here, we're going to put these new services in. Parents, you must know about them and you must agree. So recovery services are supplemental to current programs and services. And so where do they go in the IEP? They can either go under supplementary aids and services, anticipated needs, related services, or notice of the offer of FAPE. So those are the sections. It should be clearly labeled that these are recovery services due to COVID-19 and include, again, the frequency, the amount, the location, and the duration. So the time frame for determining whether recovery services are warranted is also addressed. And basically, it's the timelines as we see in Executive Order 2020-05 and the additional conditions for completing the 2019-2020 school year outlined in Executive Order 2020-65. Determinations about whether or not a student should have recovery services must be made by December 2020. And these determinations are supposed to be prioritized so that these children don't regress more. There may be summer learning, supplementary after-school programs, additional classroom instruction, online learning. They can be in any of those forms. The funds for these services are available to the school districts through September of 2021. So once again, there is no excuse that our district doesn't have the money. If the parents and the district disagree about recovery services, there is no entitlement, there is no due process, this is, as I said, this is cooperative, this is coming together, working together for the benefit of children. And if the district fails to provide the recovery services, again, you really don't have a legal remedy. You can, contact the director of special ed with your concerns. You can ask for a facilitated IEP meeting, which is when a neutral third party comes in and talks about it. You can require mediation. You can file a state complaint, or you can request a due process hearing because it's a denial of FAPE. But again, the IDEA is not on your side because it does not mention recovery services. So lastly, the document that guidance talks about the difference between compensatory education and recovery services, and we already talked about that one is mandatory and one is not, one is in the IDA and one is not. And the bottom line here, folks, is cooperation. And we got to stand back, we got to get off our soapbox, we have to look very, very subjectively at our own children and very, very objectively at their learning and how they've been taught. And we have to find a resolution to make up from what they lost, which the Michigan Department of Education recognizes that every child with an IEP has lost educational opportunity. So step one is done. So now let's be creative. Let's get these recovery services in place. Let's be ready for the IEP meeting. And let's go give our kids a different approach for different learners. So with that, I'm Lisa Kirsch Satawa. I will post this on our Facebook page for those of you who would like your very own copy. And as I said, we will not be going live the rest of the week. But I will see you all on Monday. Have a wonderful, wonderful rest of the week and be the best you so your kids can be too. Bye.